Good morning, everybody. This is the beginning of the second part of the second tranche of the inquiry's substantive evidential hearings. Mr. Barr, KC, Counsel for the inquiry, is going to make his opening statement, which will take him, I'm told, about 2 hours. At the end of that, we will have a short break and then resume with other openings. Everybody says, by way of opening, will be broadcast, but subject to a 10-minute delay. Mr. Barr.
Thank you, sir. We now commence phase 2 of tranche 2 of our hearings. During this phase, we will be adducing evidence in relation to our investigations of the deployments of 7 open former SDS undercover police officers. That is to say, those whose cover names have not had to be restricted. We intend to call 4 of them to give oral evidence. A great deal of the reporting of 6 of these 7 undercover officers relates to animal rights activists. Examining the SDS's infiltration of the animal rights movement will be a very important part of our task in phase 2. 26 members of the public who were affected by the deployments of the phase 2 officers will be providing evidence, either in person or in writing. 22 are due to give oral evidence. Witness statements made by 11 closed former SDS undercover police officers and the former partner of one of these officers will be published, subject to the operation of the restriction order process. Likewise, documents from our investigation of all Tranche 2 era closed UCOs. Some closed former officers will be giving oral evidence in closed hearings at a later date. Closed officers are those whose real and cover names have had to be restricted. We have investigated 14 former SDS managers as part of our Tranche 2 investigation and have been able to obtain witness statements from 9 of them. Those statements and documents will be put into evidence. The remaining managers were either deceased or too ill to give evidence. 5 former managers are due to give oral evidence. In addition, we will be putting into evidence various documents which are relevant and necessary to the investigation, but which are not specifically associated with an individual manager, former undercover officer, or civilian. Whether the undercover deployments in question were capable of justification, the sexual deceit of women, both admitted and alleged, reporting on black justice campaigns, the alleged participation of undercover police officers in serious offending, potential miscarriages of justice, failure to declare the involvement of undercover police officers to prosecutors or courts, violation of legal professional privilege, alleged participation in torts, the influence of UCOs within groups, the continuing use of deceased children's identities, and officer welfare will be key aspects of our investigation in this phase. So too will the knowledge, attitude, actions or inactions of managers within the SDS in relation to these and other issues. Standing back from specific events, the culture of the unit will remain an important overarching theme. I will concentrate mainly on outlining the 7 open deployments which we are investigating and seek to draw out the key events and issues which arise in each case, whilst touching upon some of the evidence that will be adduced. HN11 Detective Sergeant Mike Chitty used the cover name Mike Blake. He was deployed between April 1983 and June 1987 into the animal rights movement in South London, particularly the South London Animal Movement, or SLAM. Our understanding is that Mr. Chitty lives abroad. We have not been able to obtain a witness statement from him. Consequently, he will not be giving oral evidence. However, we are putting into evidence notes of his interviews with police officers from Operations Herne and Sparkler, as well as necessary documents from amongst those that we have recovered. DS Chitty, on his own admission, entered into sexual activity with female activists whilst he was undercover. This included a relationship with the woman we are calling Lizzie. He is recorded as having told officers from Operation Herne that during a long deployment, undercover officers could not keep avoiding relationships and soft drugs. He is also recorded as telling Operation Herne that SDS managers would have known that undercover officers were having sexual relationships, but not condoned them. A particularly striking aspect of his conduct is that he remained in contact with members of his target group, including Lizzie, after his deployment had ended. This was eventually discovered. There is evidence that DS Chitty went so far as to propose marriage to Lizzie. DS Chitty is recorded as describing SLAM to Operation Herne as a group which was, quote, never really up to much and didn't warrant the reputation that they had. A comment clearly relevant to the issue of justification. However, there is some evidence that DS Chitty's intelligence was thought to be of value for public order policing purposes. DS Chitty also reported on the Animal Liberation Front, or ALF, and other criminal animal rights activity. Both the accuracy and utility of this reporting will need to be examined. Robin Lane socialised and campaigned with Mike Blake extensively, including, for example, at meetings and parties held in people's private homes. He describes Mike Blake as a close friend and low-level campaigner in SLAM. Detective Sergeant Chitty was one of 18 people arrested at a British Union Against Vivisection, or BUAV, demonstration on the 4th of November 1984, which led to him being charged with obstructing the highway and remanded to appear at Thames Magistrates Court on the 2nd of January 1985. He is recorded as having pleaded guilty and having been bound over. He appeared with numerous others, some of whom pleaded guilty and others who did not. The reaction of management, as it was in some other cases of SDS UCOs being prosecuted, was that it would improve his standing within his target group. The documents record that the chain of command was informed of events up to and including the Commander Ops. There is no reference to the court or prosecution being informed, although there is a reference to liaison being maintained with the Chief Superintendent Lintott. Detective Sergeant Chitty is recorded as telling Operation Herne that he believed that Detective Sergeant Bob Lambert had led the cell which attacked Debenham's stores, of which Jeff Shepherd and Andrew Clark were members. However, he had no direct knowledge of events and a strong dislike of DS Lambert. In his first Herne interview, he is recorded as stating that he knew Jeff Shepherd well and thought that he would follow anyone. However, in a subsequent interview, he is recorded as telling police that he only met Shepherd once. Detective Sergeant Chitty is recorded as telling Operation Herne that Lambert bragged about fathering a child through a relationship whilst deployed, and that it was common knowledge in the office at the time that Lambert had fathered a child. He is recorded as telling Operation Sparkler that he was aware of Lambert's sexual relationships with both Jackie and Belinda Harvey. The bragging he appears to have told Operation Sparkler was confined to fellow UCOs. The notes of D.S. Chitty's second interview with Operation Hearn record allegations that it would not be unusual for UCOs to withhold intelligence about serious events to avoid having to give evidence in court and thereby bring their lucrative deployments to an end. They also record an allegation that intelligence reports were sometimes significantly altered by a supervisor. There is evidence that D.S. Chitty's SDS work had a considerable negative effect upon him, as it has on others. He set out the nature and consequences of these problems in a letter to the Commissioner, dated the 13th of March 1994. A consultant psychiatrist subsequently assessed him as having been psychologically unsuitable for the undercover work that he did, and subsequently inadequately supported. The conclusion to the psychiatrist's report states, quote, "He comes across as a modest man who has been damaged by his work and the lack of appropriate support and counselling throughout his ordeals." These documents were created in the context of disciplinary proceedings against D.S. Chitty, which led to him being reduced to the rank of constable. D.S. Chitty relied upon the effects of his deployment as mitigation. He was subsequently medically discharged from the Metropolitan Police Service. The proceedings against D.S. Chitty, which related to his travel and subsistence claims whilst working on protection duties after his SDS deployment had concluded, precipitated a crisis for SDS managers in 1994. They feared that he would respond by publicly exposing the SDS, which he threatened to do. Management's reaction will be the subject of examination in Tranche 3, when we intend to call the relevant managers. Detective Sergeant Robert, or Bob, Lambert infiltrated London Greenpeace in North London and other groups between 1984 and 1989. His ultimate target was the ALF. He used the cover name Bob Robinson, which, in accordance with standard SDS practice, was based upon the identity of a deceased child. He will be giving oral evidence. D.S. Lambert is known to have entered into at least 4 deceitful sexual relationships and to have fathered a child, who we are referring to as TBS, with an animal rights activist who we are referring to as Jackie. A woman who we are referring to as CTS appears to be the first person with whom Lambert formed a deceitful sexual relationship early in his deployment. D.S. Lambert admits that he did form a sexual relationship with her. Martin Lowe was active within London Greenpeace at the time. His written account to the inquiry is that it was CTS's first relationship. The relationship was not hidden from other activists. D.S. Lambert was much older than CTS. She was besotted with him and really badly hurt when he broke up with her. The breakup affected Mr. Lowe's friendship with CTS. Mr. Lowe will give oral evidence, and we will explore discrepancies between his account and D.S. Lambert's. There is no dispute that Jackie was deceived into a sexual relationship by D.S. Lambert without his disclosing his real identity. Their paths crossed at a demonstration outside Hackney Town Hall in the autumn of 1984, and, on Jackie's account, they began dating a few weeks later after D.S. Lambert invited her out for dinner. She ended the relationship in early 1987, but maintained contact with Bob Robinson. However, there are numerous differences in the accounts of the relationship provided by Jackie, Lambert, and other witnesses, some of which we shall need to explore. Jackie has provided a witness statement describing how she fell completely in love with Bob Robinson and wished to settle down and start a family with him. She explains the impact which Bob Robinson's departure had on her, her attempts to find him, and the serious consequences of discovering his deception. She will be giving oral evidence. TBS, Jackie and Bob Lambert's son, was born during the relationship and has made a written witness statement which will be put into evidence. It provides a moving insight into how the events we are investigating not only made, but have also shaped his life. Bob Lambert has stated to the inquiry that he informally told Detective Inspector Barber about his sexual relationship with Jackie, that she was pregnant, and that he believed he was the father. According to Lambert, the conversation took place in a pub and concluded with Detective Inspector Barber deciding that he did not need to report the matter and leaving Lambert to deal with the situation. D.I. Barber is deceased. We therefore do not have his account. D.S. Lambert told Operation Hearn of a third, brief sexual relationship with a female London Greenpeace activist. He has expanded upon that admission in his witness statement for the inquiry, in identifying her as a woman who we are calling RLC. He states that this relationship took place sometime in 1986. Belinda Harvey has stated that she was a recent graduate and not an activist, making her way in London when she met Bob Robinson at a house party in East London in April 1987. She describes how Bob Robinson soon asked her out on a date, an assertion corroborated by a letter which she has exhibited. She states that she quickly fell in love with him and changed the course of her life as a result of the relationship. On her account, the relationship lasted for 1 year and 10 months. He lied to her about his real age and sought to draw her into activism. The fact that they were in a relationship was obvious and not hidden. She was deeply troubled when her former home was raided by police purporting to look for Bob Robinson, and distraught when Bob Robinson told her that he had to flee the country and wanted to go with him. Discovering who Bob Robinson really was in 2011 had a profoundly negative effect on her and her family. She is deeply hurt and feels angry and violated. Bob Lambert admits the fact of the relationship, although there are differences between their accounts, which we shall explore where necessary. We will be hearing oral evidence from Belinda Harvey. A witness statement obtained by Operation Sparkler from Simon Termaine, a close friend of Belinda's, who states that he was also befriended by Bob Robinson, will be admitted in writing. Mr. Termaine has since passed away. D.S. Lambert has set out 2 grounds for believing that managers might have known about or suspected his sexual relationship with Belinda Harvey. First, he states that a field officer gave him to understand that management had photographic evidence showing them together. Second, he alleges that Detective Sergeant Mickey Couch found a photograph of them together when D.S. Couch searched his flat. D.S. Couch does not recall finding any such photograph. There are significant allegations made against D.S. Lambert to the effect that he both incited and participated in serious criminal offending. Of particular note, it is alleged by a number of witnesses that he helped to plan and then participated in the planting of improvised incendiary devices, or IIDs, at Debenhams department stores on the night of 11th to the 12th of July 1987. 3 stores at Luton, Harrow and Romford were damaged as a result, the Luton store very seriously. Andrew Clark and Jeff Shepherd were later convicted for offences relating to the attacks and subsequent activity creating new IIDs. An appeal against conviction based upon D.S. Lambert's alleged actions and undisclosed role, is currently before the Court of Appeal. We have obtained a short contemporary BBC News report about the attacks.
Is said to have started in the... Police have sealed off the Luton Arndale Centre to search the Debenham store, which was by far the worst damaged of the three. According to a police spokesman, parts of the store are dangerous because of the risk of damaged fittings falling from the roof. The fire here is said to have started in the basement and spread upwards. A warning of incendiary devices at several Debenham stores was given by an anonymous caller to the Press Association in the early hours of this morning. Claiming to represent the Animal Liberation Front, he said the attacks were a form of economic sabotage against stores in the West End and the rest of the country who sell fur coats.
Thank you. The most serious allegations concerning the attacks on Debenhams fall to be considered amongst a great deal of evidence alleging that Lambert participated in other crimes or was arrested on suspicion of having committed an offence. Some of it is disputed, some of it is not. D.S. Lambert was arrested with others in the course of a protest at Murray's Meat Market in Brixton on the 7th of December 1985. He and 4 others, including Jeff Shepherd, are recorded as appearing in court and being bound over. He was represented by the same counsel as his fellow defendants, appeared before the court, and is recorded as giving evidence in his cover identity. The contemporary documents also evidence the fact that a senior local police officer was informed of D.S. Lambert's true identity, but there is no record that the court was informed. Bob Robinson was also arrested on the 28th of February 1987 while present at a sabotage of the Crawley and Horsham hunt. D.S. Lambert is alleged to have been the driver on the night when the window of a butcher's shop in Roehampton was broken. Chris Bailey was accused of breaking the window and convicted for criminal damage. He alleges that D.S. Lambert knew that it was a third person who in fact broke the window, yet nothing was done to prevent him from being convicted. He further alleges that D.S. Lambert possessed, supplied and smoked cannabis before they travelled to Roehampton. Detective Sergeant Lambert is accused of perpetrating an arson attack on the empty home of a director of the company Biorex, or at least giving that impression to Jeff Shepherd, who states that he was acting as a lookout when Lambert pushed something through the letterbox. Paul Gravett states that Bob Robinson admitted the offence to him and chronicled it in the London ALF News. Detective Sergeant Lambert denies the occurrence of the Biorex incident. Paul Gravett accuses D.S. Lambert of writing or contributing to leaflets which incited criminal acts, including a leaflet entitled "You Are the ALF," and, as just mentioned, the London ALF News. D.S. Lambert denies the latter and has no recollection of the former. Many witnesses have provided witness statements in which they describe Bob Robinson claiming to have committed criminal offences in the furtherance of the cause of animal rights. For example, pouring paint stripper on a car used by a director of Biorex, using etching fluid against the window of a McDonald's restaurant in Golders Green, and threatening to burn down the headquarters of the Hudson Bay Company. Detective Sergeant Lambert's evidence in general terms is that he would have claimed to have committed offences which he had not actually committed if the circumstances were such that he would not be found out. Allegations of unlawful conduct by D.S. Lambert do not emanate solely from non-state, non-police witnesses. HN 109 describes being physically intimidated by D.S. Lambert during the course of the Scott affair. pushed to the wall in a pub and warned, quote, "If you leave Steph alone, we'll leave you alone." Returning to the questions of whether Bob Lambert was involved in the July 1987 attacks on Debenhams stores and whether the subsequent convictions of Clark and Shepherd might be unsafe, we have obtained a significant amount of evidence from many witnesses. I will not rehearse it in detail here, but particularly striking is the witness statement of Paul Gravett. Protected by the Attorney General's undertaking, Mr. Gravett states that his role was to place IIDs in the Reading branch of Debenhams, a task which he did not, in the event, complete. He accuses Lambert of being involved from the start and of being the person who attacked the Harrow branch. Jeff Shepherd also states that Lambert was deeply involved and committed the attack in Harrow. Helen Steele has provided a witness statement in which she, too, accuses Lambert of being involved. On her account and that of Gravett, she was invited to join the conspiracy, but declined. Belinda Harvey's account is that Bob Lambert confided to her his involvement both before and after the event. Norman Blair states that he was told that Lambert was involved. HN87, HN11 Mike Chitty, and the witness known as MSW all also provide evidence relating to the issue. Lambert denies having any information in advance of the incendiary attacks on Debenhams, which took place on the 11th to the 12th of July 1987, or telling Belinda Harvey that he was involved in the actual bombings. Bob Robinson was present at a CND demonstration in Grosvenor Square on the 19th of April 1986, when an activist, Steve Curtis, was arrested. Mr. Curtis was later charged with threatening behaviour, convicted, and appealed the conviction. He asked Bob Robinson to appear as a witness for him. According to a witness statement that Operation obtained from Steve Curtis, D.S. Lambert did give evidence on his behalf as Bob Robinson. According to the documents and Bob Lambert, he did not give evidence. The relevant special branch documents are illuminating as to attitudes because they record that DCI Waite wished Bob Robinson to give evidence in order to maintain his cover. Chief Superintendent Parker agreed and thought that D.S. Lambert should be instructed, quote, to be suitably non-controversial in what he has to say. Commander Phelan took a more principled view. He was concerned to avoid D.S. Lambert committing perjury and felt that if Bob Robinson's evidence did not meet expectations, it would also damage his credibility. Consequently, he directed that D.S. Lambert must not give evidence. However, if D.S. Lambert did have exculpatory evidence to give, even this solution left Mr. Curtis without a witness who might have changed the course of the appeal. The court and prosecutor should have been informed so that he or she could consider whether, in fact, the right thing to do was to offer no evidence. Bob Robinson is described by others as a leading figure in London Greenpeace's campaign against McDonald's restaurants, and is said by activists to have contributed to the leaflet which later gave rise to what became known as the MacLibel case. D.S. Lambert reported extensively on London Greenpeace's campaign against McDonald's, including, for example, on various days of action, legal warnings from McDonald's to desist, and about who was corresponding with London Greenpeace in relation to the campaign. A number of civilian witnesses who were active within London Greenpeace at the material time describe Bob Robinson as an influential figure. Some assert that he influenced the direction of the group towards animal rights and was thus a decisive figure. Others give evidence to the effect that that was happening anyway. Many describe Bob Robinson as facilitating or encouraging their own activism. Lambert's deployment was regarded as an outstanding success by his managers, such that he was awarded a Commissioner's Commendation. DCI Docker submitted a long report seeking the commendation, which claimed many successes had arisen from D.S. Lambert's deployment, including, amongst others, intelligence in 1984 leading to 19 arrests when South East Animal Liberation League, or SEAL, raided Wickham Laboratories in Hampshire. Ringleaders received sentences of imprisonment. Intelligence in 1985, leading to arrests at RAF Upper Hayford. Intelligence about Ronnie Lee and Vivian Smith, which was stated to have been of particular use immediately prior to their arrests. Intelligence about anarchist offending at the Wapping picket. Intelligence leading to the arrest and conviction of Andrew Clark and Jeff Shepherd. Regular prospective intelligence about Hunt sabotagers, mentioning the large-scale sabotage of the Crawley and Horsham Hunt especially. We shall need to examine the utility of the deployment in order to help answer the question whether it was capable of justification. That does not mean that we will be examining whether sexual deception was justified. It was not. HN87, who used a cover name John Lipscomb, infiltrated the animal rights movement in South London between 1987 and 1990 as a successor to Chitty. Initially, Lipscomb was deployed in Bromley, but he was later switched to Brixton. His reporting focused on Hunt saboteurs. He has provided the inquiry with a witness statement, but is presently too ill to give evidence. He appears to have found little of concern in Bromley and suspects that Chitty suggested that he start there to hide Chitty's own ongoing contact with animal rights activists in South London. Lipscomb's evidence is that he discovered and reported the fact of this ongoing contact. Lipscomb found the activists with whom he mixed in Brixton to be anarchist and more militant than those in Bromley, although you will need, sir, to consider closely whether their activities could have justified the use of the undercover tactic. HN87 himself states in his witness statement that he doubted the utility of his reporting. Whether or not you conclude that deployment of an undercover police officer could have been justified, there are obvious problems with the way in which Lipscomb actually conducted himself. He appears often to have stayed at the homes of activists, including in squats, where he befriended and shared beds with female activists. On his own account, there was sexual activity, short of intercourse, on a number of occasions. The activist we are calling Walter states that he knew John Lipscomb between 1988 and 1990. According to Walter, Lipscomb was known as Hippie John and was relaxed, sociable, and non-confrontational. He is said often to have driven a Land Rover used by Hunt saboteurs until he damaged the engine. He participated in Hunt sabotages. There were many arrests during this time, and Walter states that Lipscomb would have been party to conversations about criminal and civil proceedings. Walter also alleges that HN87 was known to be very interested in young female activists. HN87's deployment gives rise to numerous issues relevant to management, one of which is how Lipscomb came to spend so much time in squats, when earlier SDS managers had previously concluded that it would be inappropriate for a UCO to live in a squat. Detective Sergeant John Dines infiltrated anarchist groups, including London Greenpeace, between 1987 and 1991, overlapping to some extent with Lambert and then replacing him. He used the cover name John Barker, which was based upon the identity of a deceased child. It is well known that D.S. Dines formed a deceitful sexual relationship with Helen Steele. John Dines is abroad, but has cooperated with the inquiry to the point of providing 2 witness statements. However, he has declined to give oral evidence. He admits a sexual relationship with Helen Steele. Of note is his evidence as to why he deceived her. On our reading of his witness statement, he is stating that he used her to maintain his cover and obtain intelligence. In other words, cold, calculating, emotional, and sexual exploitation. Dines explains in his witness statement why he believes that his managers knew about his sexual relationship with Steele. He also asserts that sexual relationships were very difficult to avoid. These are all issues that we would particularly have liked to have explored with Mr. Dines in oral evidence. According to Ms. Steele's account in the book Deep Deception, the relationship began in May 1990, initiated by John Barker, and ultimately led to them cohabiting. Dines had often professed his love for her, expressed a desire to have children with her, and had planned with her to settle down in a home of their own, a home that he said would be financed by an inheritance. He left after feigning deep emotional problems over a protracted period, behaviour which was greatly upsetting and disturbing for Steele, who has written about how completely she had fallen in love with him by that point. She has written that they last saw one another at Alexandra Palace on the 8th of March 1992, some months after D.S. Dines's deployment officially ended. Dines's written account differs significantly from Steele's on numerous points. For example, who initiated the sexual relationship, whether they discussed having children, and when they last saw one another. He also asserts that he never intended adversely to affect her emotional well-being and sought to limit any emotional fallout. Helen Steele embarked upon protracted searches for John Barker in the 1990s and 2000s, gradually finding out more and more during a series of events which culminated in the official confirmation that John Dines was the undercover police officer masquerading as John Barker. We will be exploring Helen Steele's searches for John Barker and the police reaction to them in Tranche 3. Considerable steps were taken by the Metropolitan Police Service to try and prevent Steele from finding Dines. They included relocating Dines at one point at very significant public expense. In Tranche 3, we'll be hearing evidence from former SDS managers of the era and hope also to have the benefit of Ms. Steele's evidence about John Dines's conduct, the impact upon her and her considerable efforts to trace him. D.S. Dines states that a surveillance team observed that Helen Steele stayed at his cover accommodation in Finsbury Park overnight and reported that observation to SDS management. In Tranche 2, we will be exploring whether and to what extent Dines's sexual relationship with Steele was known about by his fellow UCOs and Tranche 2 SDS managers. Also, what the prevailing attitudes towards such relationships were. Dines was arrested at least twice during his undercover deployment. He was first arrested with 12 others in Hereford on the 6th of December 1988 in the course of a demonstration against the manner in which chickens were being transported. He was charged with an offence contrary to Section 4 of the Public Order Act 1986 and appeared at Hereford Magistrates Court, where the charges were withdrawn and he was bound over. Some of the activists who had been arrested with Dines brought complaints against the police. Dines joined them in doing so, but deliberately made a vague complaint, having consulted his managers. Of particular interest is how management handled and perceived the incident. Dines was being supported in Hereford by Detective Inspector HN 109 and Detective Sergeant Hyde. The documents record a deliberate decision not to declare their interest and a view that events assisted Dines's cover, in circumstances where two of the activists with whom Dines was mixing were suspected of involvement in the planned use of improvised incendiary devices. John Dines was present at the poll tax riot on the 31st of March 1990, where he was arrested in possession of marbles and held in custody with many others. He gave a false name when arrested, which was not his cover identity, but was the identity of a second deceased child, Wayne Cadogan. The fact that he was using a second false identity was known to SDS management. Dines appears to have been charged with an offence contrary to Section 4 of the Public Order Act 1986 and is recorded initially as intending to plead guilty. He was also going to seek to negotiate with the prosecution for a lesser charge. Chief Superintendent Willingale's reaction to the arrest was that Detective Sergeant Dines's arrest would further increase his standing within the group. Commander Gunn directed that Detective Sergeant Dines should in fact fail to appear in court. The documents record that Gunn decided personally to supervise, quote, the necessary action to protect Dines from legal repercussions and to, quote, cancel all records, suggesting that there is likely to have been contact with either the court, the prosecution, or both. The Trafalgar Square Defendants Campaign was established by Dave Morris in the weeks after the riot to support those facing criminal charges. HN5 reported on the campaign whilst assisting the MPS to identify those present at the riot. What appeared to Helen Steele at the time to be a third arrest and detention at Paddington Green Police Station in May 1990 appears in fact to have been an elaborate ruse designed to reinforce Dines's cover. On both Dines's and Steele's accounts, it involved a man telephoning Steele, who must have been pretending to be Dines's solicitor. It is an incident which begs questions. McDonald's issued libel proceedings against 5 London Greenpeace activists, including Helen Steele, in 1990, while Steele was being sexually deceived by Dines. As her then partner, he appears to have had considerable access to the defendants to these civil proceedings, their thinking, and the privileged legal advice that they received. Dines himself was conspicuously absent from the list of defendants on the writ. These matters on their own merit investigation, but will fall to be explored with managers in a wider context, namely whether and to what extent SDS intelligence was being used to assist McDonald's, either to protect itself from London Greenpeace's campaign against it, or to assist it in the litigation. It is known that McDonald's engaged private detectives to infiltrate London Greenpeace. It further appears to be the case, from documents that we have obtained, that both the security service and the SDS were aware of that fact. The security service had some interest in Dines's deployment, although it appears to have been focused on the broader anarchist field rather than animal rights as such. It sought intelligence on Business as Usual, an animal rights and anarchist publication which was understood by the Security Service to be the successor to ALF-related publications which had led to convictions for conspiracy to incite criminal damage. It also sought intelligence on individual anarchists and on London Greenpeace as a group, which it considered to be anarchist and subversive. The Security Service was sufficiently interested that it debriefed Dines at the end of his deployment. Of note is the informed opinion expressed by Dines about anarchists, as recorded in the record of the debrief. Quote, "Anarchists pose virtually no threat." The above comment falls to be considered together with the fact that Dines was awarded a commissioner's commendation for his undercover work. The relevant documents state that the basis for recommending a commendation appears to have been the intelligence obtained by Dines on anarchists, the campaign against the community charge or poll tax, and intelligence about animal rights extremism. Particular emphasis is laid on what is claimed to be intelligence on a plot to contaminate the human food chain, specifically the drink Lucozade. Save that there is a striking absence of reporting on the Lucozade issue, amongst the documents that we have recovered, the contemporary documents do evidence reporting on anarchists, the campaign against the poll tax, and animal rights activism, including actual and alleged acts which broke the law. We will be exploring the justification for the infiltration of London Greenpeace with many of the witnesses in this phase. Again, I should, however, make absolutely clear that we are not investigating whether the sexual deception of Helen Steele was justified. It obviously was not. Rather, we are investigating whether any undercover infiltration of London Greenpeace at all was justified. There are documents based on Dines's intelligence which, if taken at face value, appear to have policing value. For example, he is described at one point as being well placed to see whether firebombing plans ever get beyond the talking stage. On another occasion, it appears that he was able to provide intelligence about a potential attack on a site occupied by Unigate, in consequence of which protective measures were taken. Two long reports, which were signed by Detective Chief Inspector Gray, provide a detailed assessment of the role that anarchists were playing in public disorder. The first covered their role in the poll tax riot. The second was a more general assessment. The reports both concluded that anarchists were far less of a threat than portrayed in the media. Moving back to the question of DS Dines's conduct whilst deployed, there is an allegation that Dines struck a member of the public for making a racist comment whilst undercover. Dines has stated that he has no recollection of any such incident. An activist states that in 1991, John Barker offered him explosives from a quarry. Gabriel Bosley states that Dines came to her home, where she wrote a legitimate leaflet with another activist and Dines, although she states that he contributed little to the work. Paul Gravett describes John Barker as having been influential, helpful, trusted, and supporting all forms of direct action. He was signatory on the group's bank account. Gravett accuses Dines of throwing flour at police at the 1991 Game Conservancy Ball at the Dorchester Hotel. But Jeff Shepherd was arrested, charged, and convicted for the offence. Dines, he states, acted as a defence witness, an assertion which Dines denies. Jeff Shepherd states that he appeared in Marlborough Street Magistrates' Court for throwing flour, which John Dines had in fact thrown. He also alleges that Dines was involved in the production of the publication Business as Usual, something that Dines accepts. Gravett gives a detailed account of the access which he states John Barker had in the MacLibel case and the role he played in the associated campaign. Dave Morris describes John Barker as helpful, strong, and influential, a man who pushed for militant action. He provides a detailed account of John Barker's access to details of the MacLibel case and his actions within the MacLibel support group, which we will explore. Walter states that he met Dines at meetings of London Greenpeace and in public houses afterwards. He describes Hunt supporters as having been wary of Dines and exhibits a photograph of Dines at a hunt. Belinda Harvey states that she was introduced to John Barker by Bob Lambert and that she saw him at parties and the pub. She thought he was nice, trusted him, and they got on. This evidence begs the question whether Dines in fact knew of the sexual relationship between Bob Lambert and Belinda Harvey, which Dines has denied in his witness statement. A number of civilian witnesses are critical of the tone of Detective Sergeant Dines's reporting, as well as their accuracy and relevance. Such criticisms are not limited to DS Dines's reporting, but there are, for example, official reports attributed to Dines which display a lack of basic respect towards activists by treating their deaths with levity rather than dignity. Finally, on the subject of John Dines, I draw attention to an assertion that he lived with Helen Steele at an address which backed onto the home of George Silcott. How accurate that is, whether it was deliberate and or whether it was used in any way by the SDS, fall to be considered. Dines denies any specific interest in either the Broadwater Farm Defence Campaign or the Tottenham 3 campaign, save insofar as they were supported by activists. Stafford Scott states that John Barker was never involved in the Broadwater Farm Defence Campaign and had no access to its records. However, he states that he was given a photograph by Helen Steele of Dines at a protest outside Her Majesty's Prison, Wormwood Scrubs. HN 122, Neil Richardson, infiltrated the West London branch of the Revolutionary Communist Party and then Class War between 1989 and 1993. He will give oral evidence. He was recruited pursuant to the new procedure, which appears to have been the product of learning from the then recent Scott affair. DCI Gray, the then head of the SDS, was required to present the case for HN 122's recruitment at a meeting also attended by Commander Howley, Commander Gunn, and Chief Superintendent Smith. His cover name was derived in part from that of a deceased child, Neil Robin Martin. Neil's mother, Faith Mason, has provided a powerful witness statement which tells his story and describes the impact on her and her family of learning that Neil's identity had been used in this way. There is evidence which suggests that HN 122 travelled to the area where Neil's family lived, although HN 122 has no recollection of doing so. HN 122 deployed in or around October 1989. The security service was informed about the deployment, as was a normal part of the relationship between the SDS and the security service at that time. The records show that the security service appreciated the intelligence that it received about the RCP's London members, supporters, branch activities, and national events. In the autumn of 1990, following a review, the security service's interest in the RCP waned. It informed the SDS that it had assessed the RCP as being an insufficient threat to national security to warrant further investigation at the same level. However, it asked the SDS to continue to send intelligence about the related Irish Freedom Movement and RCP members, which was to be directed to its residual interest desk. Of relevance to the issue of justification is a Security Service record of a liaison meeting held with the SDS on the 12th of February 1991, in the light of the Security Service's revised requirement. The SDS was stated to doubt the case for continued infiltration of the RCP on law and order grounds. The natural inference appears to be that the primary motivation for HN 122's deployment had been the Security Service's interest in the RCP. Nevertheless, HN 122 continued to infiltrate the RCP until the spring of 1992. Thereafter, HN 122 reported on class war. Initially, he infiltrated Class War Federation, or CWF, but then left to join Class War Organisation, or CWO, when the latter split off from CWF. Norman Blair accuses HN 122 of playing an active role in the breakup of class war and of effectively killing off CWF, allegations which we will explore. The Security Service took an interest in this part of the deployment. It provided a long brief for the SDS ahead of CWF's 1992 National Conference, and there is a lengthy and detailed report informed at least in part by HN 122's intelligence. HN 122's intelligence was described as particularly useful by the Security Service. Nevertheless, the SDS decided not to replace HN 122 with a dedicated source within the CWO. According to the Security Service records that we have obtained, this was because it was not a law and order threat. The Security Service debriefed HN 122 on the 10th of September 1993, just before his deployment came to an end on the 18th of September 1993. At that meeting, HN 122 opined that the threat to national security from CWO and CWF was very low. The question that arises is whether HN 122 served a valuable function, confirming that the RCP, CWF, and CWO were not a threat, or whether he should not have been deployed into these groups at all. I note in that regard that in September 1987, the SDS is reported to have regarded Class War Collective as of no interest. Norman Blair has stated that an HN 122 was withdrawn after being accused of being, quote, a cop. Special branch documents record that HN 122 was mentored by HN 19 and was himself a mentor to HN 15 Detective Constable Mark Jenner. He is also recorded as attending a meeting of mentors in 1995, at which the psychologist Dr. Felicity Gibbling was present. He may therefore be able to assist on the efficacy of the SDS's mentoring scheme. Of concern in the context of our investigation into whether SDS targeting was influenced by racism are the terms in which an officer from Operation Hearn has recorded a 2013 interview with HN 122. The material passage reads, quote, posted C Squad, Blacks and Browns desk, single-issue anti-racist groups, closed end, and then we've gisted mid-1980s. Andrew or Andy Coles infiltrated a number of animal rights groups in South London between 1991 and 1995. He will give oral evidence. He used the first name and date of birth of a deceased child and added the surname Davy to form his cover name Andy Davy. His deployment began by focusing on pacifist, anarchist and environmentalist groups due to the start of the Gulf War, and subsequently developed to focus on animal rights groups, including London Boots Action Group and Brixton Hunt Saboteurs. The most significant issue arising relating to his deployment is whether he deceived the woman we know as Jessica into a sexual relationship. He denies that any sexual relationship occurred. Jessica states that Coles initiated a sexual relationship with her when she was 19, and he was pretending to be a 24-year-old animal rights activist. He was, in fact, a 32-year-old, married, undercover police officer. She perceives that Coles targeted her due to her specific vulnerabilities at that time. She states the relationship started sometime after she moved into her East London address during the first half of 1992. She describes that Coles lunged at her and kissed her whilst they were watching TV, and at the time was a very naive and inexperienced teenager who did not resist Coles's sexual advance, even though she did not find him at all attractive. She describes a very awkward and private relationship thereafter, about which she was embarrassed. In the early autumn of 1992, she travelled to France to work there, having discussed with Coles whether to take the opportunity. She returned to the UK to spend time with him at his cover accommodation after he sent her a letter suggesting that they should each see other people. She returned permanently from France in the summer of 1993 and stayed between her parents' house and Coles's cover accommodation. Jessica ended the relationship with Coles when she met someone else, referred to as NM, in memorable circumstances in Coles's flat. He took it amicably, seemed unbothered, and continued to hang around the South London address into which Jessica moved with NM and others. Jessica denies being the extremist that she is portrayed as being by Coles. The inquiry has obtained 2 letters written by Jessica to a friend whilst she was in France, which appear to corroborate her account that Coles was her then boyfriend. Jessica describes the revelation that Coles was a UCO as having a devastating and traumatic impact upon her life, health, and relationships. She has since thought to communicate her side of the story and to hold Coles to account. Amongst other things, she has leafleted in Peterborough, where Coles was an elected councillor, and she alleges that she was threatened by Coles. Coles denies any sexual relationship with Jessica. He states that he knew Jessica well and spent time with her, generally at her East London address after LBAG meetings, because he saw her as a way into the ALF. His account is that Jessica initiated conversations about them having a sexual relationship, which he deflected. He denies that she stayed at his cover address when she came back from France. He states that their friendship ended when she moved away from London. A female animal rights activist, who I cannot name for privacy reasons, will give oral evidence in private session about an incident between her and Coles. One evening in early 1993, he came to her flat, lunged at her, tried to kiss her, and chased her around the flat for a couple of minutes. She describes that it was very unpleasant, and she felt angry and upset. She remembers telling Matt, HN1. Coles denies this ever happened and states that this woman had poor personal hygiene. Robin Lane states in his witness statement that in around 1993, he and his then girlfriend introduced Coles to a French woman they knew. He states that afterwards the French woman told him that she and Coles had a one-night sexual relationship and he was a bit rough, but she said she didn't mind that. Coles has not yet had an opportunity to respond to this account. Jessica describes an account given to her by another activist, Andrea McGann, who has now passed away, who told her that Coles had tried to kiss her while Jessica was in France. Coles has not yet had an opportunity to respond to the allegation described by Jessica. Coles's evidence is that he undertook a large number of roles within the groups on which he reported. He states that he took over responsibility for a group called Support Animal Rights Prisoners with an activist we are calling Callum. He was a founder member of Earth First UK. He was one of 3 activists who ran the Animal Liberation Front Supporters Group, or ALF-SG, and was, quote, in reality, second in charge of ALF-SG. He assisted with production of the bi-monthly newsletter for London Boots Action Group. He was an organiser and newsletter author for London Animal Action. He was the London representative for South East Animal Rights Coalition. He was involved in the founding of the London Animal Rights Coalition and produced its newsletter. He was involved in the production, distribution and sale of the newsletter The South East Liberator, and he assisted in the distribution of the ALF-SG newsletter and the animal liberation publication Archangel. Coles states that he would not have been able to obtain information about ALF activity without being involved to some extent in criminal activity, but this was at the lower end of the scale. He generally drove activists to actions, on occasions entered premises himself, and on occasions assisted in the liberation of animals by driving them away in his van. He states that Andrea McGann got him into the ALF cell of which she was a part. Coles was arrested on the 19th of November 1994 whilst attending a Hunt saboteurs demonstration at the Essex Farmers' Hunt. He was charged in the false cover name Andy Jones for an offence of aggravated trespass under Section 68 of the Criminal Justice and Public Order Act 1994, along with a number of other individuals, some of whom Coles may have driven to the event. Coles, as SDS managers, instructed him not to appear at court, a course of action endorsed by senior Metropolitan Police Special Branch officers, including Commander Buchanan, who proposed the arrest could be exploited for his exfiltration. At least some of the other activists arrested that day were convicted, including a man we are calling AFJ, who will give oral evidence. The convictions will be further examined during the management evidence in Tranche 3, and in due course you will need to decide whether to refer these convictions to the Miscarriages of Justice panel. Jessica was arrested along with others at a demonstration at the annual Horse and Hounds Ball on the 5th of March 1992. She was charged with assaulting a police officer and a fray. She was acquitted on appeal. Jessica's evidence is that the charges she faced were based on lies by the police. Coles confirms that he attended this event and saw either McGann or Jessica throw a flower bomb, but he cannot now remember which. Notably, the name of the perpetrator has not been included in the contemporaneous SDS intelligence report, despite him being sure he provided it to his managers. Coles suggests this was to protect his identity. Coles also reported on a defence planning meeting that he attended in advance of Jessica's trial, the purpose of which he states was to design a false defence. However, there is no such detail within the report itself, which reports on proposed defence witnesses. He explains that the propriety of reporting the defendant's intentions in relation to court proceedings was not a consideration at the time. Coles states that as a result of his relationship with Callum, he agreed to hand over £700 diverted by Callum from an ALF-SG campaign stall to an activist called Brendan McNally, who was acting as an intermediary for Barry Horn, an activist planning an incendiary device campaign. Coles states he handed over the cash under the eyes of a full MPSB surveillance team. Callum has stated in his witness statement that this is not remotely true, and he is certain he never agreed to £700 being passed to Horn. Documents in HN2's hearing bundle demonstrate a concern by the SDS management about disclosure of SDS intelligence during criminal proceedings. Criminal proceedings at Reading Crown Court were discontinued in 1993, according to records made by the SDS management at the time, due to the trial judge's ruling that an intelligence report previously provided by Coles failed to be disclosed to the defence. As a result of this, the Detective Chief Inspector of the SDS in 1993, HN 86, proposed a new system for recording SDS intelligence, where individuals would not be named in intelligence reports assessed to be particularly sensitive, in order that, in his view, no disclosure obligation would arise within criminal proceedings. The inquiry will explore further with SDS managers in Tranche 3 what this reveals about their attitude to the criminal justice system. In early 1994, the SDS management directed Coles and his then pregnant wife to move house due to the proximity of an activist who we're calling GSV to Coles's real home, compounded by threats of disclosure made by Mike Chitty. The MPS paid for his removal costs, legal fees and approximately £30,000 to clear the negative equity on his house, authorised by the Home Office. Much, but not all, of what we call the Tradecraft Manual was drafted by Coles. He states that at the end of his deployment in 1995, Bob Lambert, at that time the detective inspector in the SDS, asked him to write a report recording his experiences in order to assist incoming UCOs. He states that he did not anticipate this being made into a manual, but he did make the front cover and possibly the index. The content of the Tradecraft Manual, on topics such as sexual relationships, the use of deceased children's identities, and involvement in crime, will be important matters for the inquiry to explore in this phase and with SDS managers, including Lambert, in Tranche 3. From 2000 to 2002, Coles worked in the National Public Order Intelligence Unit, the NPOIU, as an operations manager at Detective Inspector rank. We will receive evidence from him about this in Tranche 4. HN1, Matt Rayner, that is his cover name, infiltrated a number of animal rights groups between 1992 and 1996, initially by becoming a member of the London Boots Action Group, later subsumed into London Animal Action and involving himself in hunt sabotage via the West London Hunt Saboteurs Association. He was based in northwest London but eventually reported on activists as far afield as Liverpool and Manchester with some regularity. He used the identity of a deceased child, Matthew Edward Rayner, who had died aged 4 of leukemia. Caden Blake, Matthew's older sister, will give evidence about her brother and the impact the use of his identity has had on the family. Matthew's brother has also provided written evidence to the inquiry. Rayner has admitted to the inquiry that he had a deceitful, intimate and sexual relationship with Denise, or Liz, Fuller. He met her probably through her involvement with LBAG within about 6 months of commencing his deployment, and reported on her before, during and after the relationship, which commenced in 1993 and lasted until 1995. Although Rayner's account describes Denise Fuller making, quote, the first move, following a period during which they had begun to spend time alone together, she strongly denies that this was the case. Rather, Ms. Fuller points to a May 1993 report about her by Rayner concerning a point of particular vulnerability in her life, and identifies that as the time when he initiated an intimate relationship with her. At the time, Denise Fuller found Matt Rayner to be a kind, gentle, protective, and caring boyfriend. She describes him as stable, outgoing, and solid. She recalls spending 3 to 4 nights per week together, including nights at his cover accommodation. He was, in his real identity, married, whilst engaging in the deceitful relationship with Ms. Fuller, but nonetheless describes his feelings as genuine. She does not believe that he had any real feelings for her. She contrasts his behaviour towards her with his contemporary intelligence reports, about which she has now seen. Rayner deployed in January 1992. LBAG had only recently been set up. He attended its monthly meetings and went on pickets and participated in demonstrations it organised or attended. He describes Paul Gravett as spearheading LBAG events and the group as secretive, its trusted members aware that illegal activity and direct action were taking place, albeit it was not discussed at public meetings of the group. When LBAG was subsumed into LAA, Rayner reported on that group, attending its inaugural meeting in October 1994. He describes it as, quote, a focal point for animal rights campaigning, better funded than LBAG, and identifies its organisers, Paul Gravett and Brendan McNally, as, quote, hardliners within the movement. He became a signatory on the LAA bank account and describes himself as a reliable member of the group by 1995. Rayner came under suspicion early in his deployment, primarily from an individual whom the inquiry is calling George, and who appears to have been behind the resurrection in 1992 of a group known as Anarchists for Animals, as well as being involved in a number of other groups formed around animal rights issues and a campaign against chicken slaughterhouse in Leyden Street, London, in which Rayner took part. Those suspicions came to the attention of Andrew Coles, then deployed as Andy Davey, who reported them to SDS managers. A significant issue arising from Rayner's deployment concerns his knowledge of and involvement in events leading to Jeff Shepherd's 1995 convictions for possession of a firearm and ammunition found at Shepherd's home when the police raided it on the 26th of May 1995 and in connection with the planting of an incendiary device in Boots in Enfield. Those convictions are currently the subject of an appeal by Shepherd, who alleges that not only was Rayner aware of the firearm and test-fired it with Shepherd, but that he encouraged him to make use of it to shoot a vivisector by offering to act as driver. Rayner denies these allegations and others which accuse him of being responsible for the Boots incendiary device, and says that when Shepherd told him that he had acquired the firearm, he advised Shepherd to get rid of it. The SDS annual report for 1995-1996 asserted that it was preemptive intelligence from an SDS officer which led to Shepherd's arrest in May 1995. Accounts taken from the investigating and arresting officers suggest otherwise. They point to two factors. First, that they were investigating the use of improvised incendiary devices, in respect of which Shepherd was identified as a suspect due to the similarity of the devices with those used in Debenham stores in 1987. Second, that had they known that Shepherd was in possession of a firearm and ammunition at his home, they would never have entered without the support of armed officers. The inquiry has found no written record evidencing the provision of preemptive intelligence of the firearm by Rayner. Nor has it found any record that if such intelligence was provided by Rayner to his SDS managers, as he asserts that it was passed to the investigating team. The inquiry did locate on the hard drive of an SDS computer an intelligence report dated the 1st of June 1995 concerning Shepherd's possession of a firearm, but Rayner denies being the source of some of the information contained within it, most significantly the assertion that Shepherd had the firearm, quote, with the express intention of murdering Professor Colin Blakemore, the well-known vivisector. We will explore these matters further with the witnesses. Amongst other activities, Rayner reported on and participated in surprise visits made to the homes of individuals believed to have been involved in vivisection, the fur industry, or similar. He was arrested shortly after one such event near the home of a furrier in St John's Wood in London in March 1996 and taken to the police station, where he was later released without charge. In common with other SDS officers arrested following demonstrations or the like, Rayner suffered injuries during his arrest, including a fractured rib, as a result of his treatment by arresting officers, here from the Territorial Support Group. When he informed DCI Edmondson of the injury, one resulting management report attributed Rayner's injuries to the general activities and actions of those taking part, implying injuries received during the demonstration or a scuffle, rather than at the hands of the arresting police officers. This was not the first time he had been arrested in his cover identity. In August 1995, he was arrested in North Yorkshire, where he had travelled in order to disrupt a grouse shoot. Rayner accepts it is likely that he drove a number of activists there from London. The SDS management record of his arrest indicates that he was charged with a public order offence involving the use of threatening, abusive or insulting words or behaviour, or disorderly behaviour. It goes on to describe the activists, presumably including Rayner, seeking to engage members and supporters of the shoot in verbal and physical confrontation, and a fight breaking out between activists and members of the shoot. Police were quick to intervene, and a group of 9 activists, including Rayner, were arrested. Rayner denies any involvement in physical or violent confrontation. Again, in common with other examples of undercover SDS officers being arrested, the management view expressed was that Rayner had acted with exemplary professionalism, maintaining cover and enhancing his reputation within a security-conscious group of committed activists. Recommendations were that he should not break ranks with his co-accused, but rather should attend court in his cover identity and enter a not guilty plea. In the end, it appears that the criminal proceedings were discontinued, and so no court was misled as to the true identity of a person appearing before it. The same cannot be said of Rayner's 2 appearances in court as a defence witness. As to the first, about which the inquiry has found no contemporaneous documentary evidence, Rayner recalls giving evidence on behalf of Jeff Shepherd, who was convicted of a Public Order Act offence. The second was on behalf of an individual we are calling LTD. In respect of both, Rayner recalls discussing giving evidence with his managers, but cannot imagine that his real identity was disclosed to the court in either case. After the second occasion, his manager, by then D.I. Lambert, commented that he had, quote, behaved in a thoroughly professional manner throughout. Rayner agrees. Neither he nor Lambert appears to have considered that the court was misled. What these episodes reveal about SDS attitudes to the criminal justice system is likely to be a topic of interest now and again in Tranche 3 when the relevant managers are questioned. The hierarchy of SDS interests by this stage of the unit's existence seems at least to be clear. The first and primary interest being to ensure that deployments were not interrupted by overt involvement in the criminal justice system, even if that meant providing a false name to a court and or failing to provide significant information to the prosecution or a court, viz. That a defence witness was in fact a police officer. Rayner's deployment was extended in the summer of 1995 beyond its originally intended end date of February 1996. Management records indicate that he was considered to be, quote, on the verge of a breakthrough into the very upper reaches of the ALF. Whether or not that was an accurate assessment is something that you may wish to explore, sir. At the end of his deployment, Rayner wrote or contributed to an SDS report purporting to summarise the current state of the ALF, seeking to outline the significant differences between the animal rights activist, the ALF activist, and the most committed ALF extremist. The report asserted that there were only about 20 committed ALF extremists in the United Kingdom, defining an ALF extremist as someone who accepted, quote, the need to cause serious harm to people and property if the cause is to be advanced. ALF activism, on the other hand, was described as, quote, the generally accepted term for the use of direct action, which is often against the law in furtherance of the cause. Rayner himself appeared on the list of ALF extremists. The inquiry has found evidence of this report being forwarded at the behest of the Animal Rights National Index for the attention of the Home Secretary. That version did not contain two assertions of interest found in what appears to have been an earlier draft, that the overt groups such as LAA are only of passing public order interest, not significant in its own right, and, quote, it is difficult to see how future operations by the unit will be able to achieve anything like the success enjoyed so far. There are fewer ALF extremists now than at most times in the past. Rayner's deployment overlapped with that of Andrew Cole's, albeit the latter was based mostly in South London, and there is evidence within the reporting of them attending the same events, for example, LBAG meetings. Rayner denies being aware of any relationship between Coles and Jessica, although he knew Coles was close to her. Asked more generally about Coles's alter ego Andy Davey and women, Rayner has confirmed that one female activist referred to him as creepy and expressed, quote, her clear disapproval of his creepiness or amorous intentions. It felt like she described him with a shudder. Rayner also overlapped with officers whose deployments will be considered in Tranche 3. HN26 Christine Green deployed at the same time as Rayner into animal rights circles and entered into a sexual relationship with an activist during her deployment. It appears likely that in her case, at some stage, she disclosed to the activist that she was in fact a police officer operating undercover. Rayner states that he knew of her friendship with an activist and assumed it was sexual. The office would have known. Rayner further recalls that Jim Boyling, HN14, made reference to being in a relationship whilst deployed, and acknowledges that he also knew that Mark Jenner, HN15, was having a sexual relationship whilst deployed. Rayner later acted as mentor to James Thompson, HN16, another officer who went on to form intimate relationships in his undercover identity, albeit Rayner denies knowing about them. Questions arise to explore with Rayner and further in Tranche 3 regarding his and SDS management knowledge of such relationships. Rayner states that relationships, quote, were seen as a grey area. They were not advised or encouraged, but they were not prohibited either. This understanding was reinforced by the fact that my managers were aware of my situation and did not tell me to stop. He identifies both Lambert and HN86 as saying things, quote, suggesting to me that they knew that there was at least the risk of relationships generally. According to Rayner, Coles would have been aware of his own relationship, having seen him together with Fuller, as would HN26, Christine Green, who once deployed was part of the same tight-knit community. When his deployment eventually came to an end in 1996, Rayner executed an elaborate exit strategy developed with SDS managers, which involved a period living in France, during which he was visited by activists, and a move to Argentina. He received a commissioner's commendation for his work. Most of the civilian witnesses are legally represented, and their counsel will be saying more on their behalves when they make their own opening statements. However, it may assist those following the inquiry to have a list and brief information about the non-state, non-police witnesses, which we have compiled annexed to the written version of this opening statement. The Tranche 2 team has obtained witness statements from 11 fully anonymous former SDS undercover police officers. It also obtained a witness statement from the former partner of a fully anonymous officer in connection with the allegation that the officer engaged in, quote, an affair during their deployment. That witness must remain anonymous, consequent upon the anonymity of their former partner. Redacted versions of their witness statements and redacted versions or gists of associated documents will be published in cases where they have not had to be wholly restricted from publication. Our approach to managers remains as it did in Tranche 1. We have investigated those managers whose postings to the SDS concluded before the end of 1992. Following this system ensures that we do not call managers before the undercover police officers whom they managed. Later managers are being investigated by our Tranche 3 team. 5 managers served as the head of the SDS during the Tranche 2 era. HN99, DCI Nigel Short, HN15, HN115, DCI Tony Waite, HN69, DCI Malcolm MacLeod, and HN39, DCI Eric Docker, and HN51, DCI Martin Gray. We have been able to obtain witness statements from Tony Waite, Malcolm MacLeod, and Eric Docker. We intend to call all 3 to give oral evidence in January. Nigel Short and Martin Gray have passed away. 4 detective inspectors fell within our Tranche 2 investigation: HN68, HN22 Michael Barber, HN39 Eric Docker, and HN109. We have obtained witness statements from Eric Docker and HN109. Both will be called to give oral evidence. HN68 and HN22 have passed away. Later detective inspectors whose service with the SDS straddle the tranche boundary, namely HN86 and HN67, are being considered by our Tranche 3 team. Witness statements have been obtained from 5 sergeants who served in the SDS in the Tranche 2 era. HN 45, HN 32 DS Michael Couch, HN 61 DS Chris Hyde, HN 59 DS John Hoochin, and HN 29 DS David Carson. HN 108 DS Brian Sutcliffe was excused from making a statement on medical grounds. Michael Couch will be called to give oral evidence, principally because he can give evidence germane to our investigation of Bob Lambert. The remaining witness statements will be admitted into evidence in writing. The Tranche 2 timeline provides a diagrammatic representation of the management of the SDS during the Tranche 2 era. The pattern which began to emerge at the end of the Tranche 1 era, by which former SDS undercover officers returned to the unit to serve in a managerial or administrative capacity, continued in the Tranche 2 era. HN 68, HN 109, and HN 45 were all former UCOs. We shall be exploring a wide range of issues with the unit's managers in this phase. The adequacy of recruitment procedures, training, guidance, supervision, support, leadership, discipline, and officer welfare require examination. So too, the practices and motivations for targeting decisions, tasking within deployments, monitoring of deployments, the value of the intelligence obtained and its dissemination, culture, attitudes and priorities in relation to secrecy, operational security, the elite nature of the unit, women, people of colour, the deceased children whose identities were used, the criminal justice system, and the civil justice system are all matters that we shall seek to understand more fully in relation to the events that we are considering. The role of more senior managers in the chain of command will be examined from the perspective of SDS managers, as well as the relationship with the security service. A particularly important factual issue will be the extent to which managers knew or cared about the sexual relationships which were occurring. There is a dichotomy in the evidence between the UCOs and managers on the question of knowledge. A number of the former UCOs state either that they told at least one manager at least something of what was happening, or state that they did not discuss it with management but believe that managers nevertheless knew. Only DCI Waite accepts that he knew something and he appears to have done little or nothing about it. We are today uploading to the website a second corporate witness statement provided on behalf of the Security Service and dated the 10th of June 2024. It is made by a Deputy Director who is the head of Human Intelligence in the Security Service and who we are calling Witness Y. Witness Y's statement complements and follows on from that provided by Witness Z in Tranche 1. It will be followed by 412 accompanying documents. The statement covers in some detail the relationship between the SDS and the Security Service during the Tranche 2 era and provides important context within which to understand that relationship. So you have also had sight of a closed statement containing further evidence. It is clear that the direct relationship between the SDS and Security Service remained strong during the Tranche 2 period. Each assisted the other, although the principal element of the relationship was always the flow of intelligence from the SDS to the Security Service. There is greater evidence of involvement of non-SDS MPS managers in the relationship later in the period. The Security Service undoubtedly considered the SDS's intelligence to be of assistance to it, and that view is expressed repeatedly in the documents. Witness Y confirms that one reason why the service is likely to have valued SDS intelligence was for vetting purposes. The foundation of the relationship continued, as in the Tranche 1 era, to be Special Branch's function to assist the Security Service to counter subversion. I have previously addressed you, sir, during the course of Tranche 1 on the definition of subversion up to and including the 1984 guidelines. Witness Y addresses a further development, namely the enactment of the Security Services Act 1989, which came into force on the 18th of December of that year. The wording of the statute superseded the Harris definition and might have heralded a change in approach to the service's work. However, Witness Y states that there was, in fact, no material change to the service's understanding of its responsibility for investigating subversion. The witness also explains that the Security Service interpreted its remit widely to cover both actual and potential threats. What did change was the Security Service's assessment of the threat of subversion. Witness Y links a series of national and geopolitical developments to a significant decline in the level of threat during the late 1980s and early 1990s. They include perestroika, the end of the Cold War, and the decline of heavy industry in the United Kingdom. Witness Y's statement is of particular interest because it explains how the Security Service responded progressively to its changing assessment of subversion. Counter-subversion work was scaled back in 3 steps, which occurred in 1988, 1992, and 1996. The 1992 and 1996 steps seem to be the most important for our purposes. By 1992, the threat of subversion was assessed as low and resulted in a decision to abandon collecting intelligence about rank-and-file members of groups considered to be subversive, unless they held positions of influence. Intelligence continued to be gathered about the groups themselves, as well as their leaders. A decision was also taken to retain historic records on rank-and-file members, which helps to explain why we have been able to retrieve so many SDS intelligence reports from the Tranche 1 and Tranche 2 eras from the Security Service. The decision was communicated to Special Branch in writing. By 1996, the threat of subversion was assessed to have fallen still further to a low to negligible level. The Management Board of the Security Service decided to reduce its counter-subversion work to what it described as a watching brief, scanning the horizon for any resurgence of subversive activity. Of particular significance for our purposes is that the Security Service looked to Special Branch to be its eyes and ears for this purpose. The consequence of these changes was that what the Security Service sought from Special Branch and the SDS for counter-subversion purposes changed progressively between 1988 and 1996, but its requirement in this regard did not cease entirely. Many, but not all, of the groups reported on by Tranche 2 SDS UCOs were deemed by the Security Service to meet the definition of subversion at the time, or to warrant counter-subversion investigation, evidenced by the various editions of the Security Service's Brief Guide to Subversion. For example, London Greenpeace is described as being a non-subversive group at its founding, but is included in the Brief Guide to Subversion, having gradually become influenced and then dominated by London anarchists. Anarchism had its own chapter in the August 1984 edition of the Brief Guide to Subversion, despite recognising it had never developed beyond small-scale and short-lived groups. In contrast to Greenpeace, London Greenpeace, CND was not regarded as a subversive group, but was studied by the security service due to the infiltration by subversive individuals. The SWP, once the most significant non-entryist Trotskyist group posing a significant subversive threat, was by 1993 judged not to cause great concern. The security service's interest in the work of the SDS was not limited to counter-subversion. The relationship also spanned counter-terrorist work, and Witness Y states that the working relationship between the SDS and the security service for this purpose continued. Of relevance to our work in Tranche 2, Phase 2, are documents which evidence that in the early 1990s the security service considered whether aspects of animal rights activism might be so extreme as to constitute terrorism and thus fall within their statutory remit. The conclusion appears to have been that, at its margins, the activities of some animal rights activists could be construed as terrorism. However, it was a very low priority for the security service. It would require considerable resources which were limited and was primarily a police responsibility. The provision of assistance to the police was proposed, but only where activity was of a kind that fell within the definition of terrorism. We have recovered some SDS reporting on animal rights activity from security service archives. Witness Y states that animal rights activism was not regarded as subversive in itself, and the security service considered that subversive groups did not manipulate animal rights in an orchestrated manner. However, the security service identified a link between animal rights extremism and anarchist groups. Reports about individual animal rights activists might still be of interest if they were subversive in their mindset and affiliation. For example, a security service note in 1989 recorded that whilst the security service did not study the ALF, information about individual anarchists was useful. The documents demonstrate regular discussion about targeting between the SDS and the security service, who informed the SDS of their intelligence requirements and targeting preferences. The security service adapted their own targeting in light of the SDS's deployments, and the SDS in turn adapted their targeting to cover gaps in security service coverage. The security service also made oral requests for specific information from SDS UCOs, passed numerous written briefs to the SDS, and requested identifications from photographs. A brief on the SDS prepared for the Security Service Deputy Director General Operations when meeting with the new Metropolitan Police Service Deputy Assistant Commissioner in 1989 is illuminating on the topic of targeting. The SDS is described as being, quote, sympathetic and responsive to the needs of the service. Despite being a meeting between very senior individuals, the brief suggests the security service was accustomed to contributing to the detail of SDS targeting decisions. It was said to be, quote, extremely important that everything possible should be done to discourage the SDS shifting away from three particular groups due to serious consequences for the security service. On the contrary, MPSB should be encouraged to, quote, increase the SDS attack on subversive targets of high priority to the service. The contribution made by the SDS to the work of the Security Service's F branch was said to be, quote, very significant. The Security Service regularly praised the SDS, for example, for providing, quote, superb reporting sources and for satisfying many important intelligence requirements for the Security Service. Information was described as valuable, even where the group was a low priority for the Security Service. A final observation which may assist those analysing the evidence is that witness Y explains the SDS's principal point of contact within the security service, F branch, ceased to exist in 1988. Counter-subversion was thereafter dealt with by C branch. We are today publishing on the website excerpts from the annual reports of the Commissioner of Police of the Metropolis, spanning the period 1983 to 1994. There is, unsurprisingly, no express reference to the SDS in these documents, although the importance of timely, accurate intelligence and the appropriate resourcing of events at which there is a risk of public disorder are. Some of the major events requiring public order policing, which are referred to, are ones on which the SDS reported. Others have little or nothing to do with the SDS's targets, for example, football matches, state visits, unforeseen spontaneous protests, protests driven by events overseas, and large music concerts. The 1983 report specifically praises CND's organisation and cooperation with the police, while specifically criticising the contrasting behaviour of some animal welfare organisations. The same report evidences the fact that a large number of MPS officers had served at Greenham Common in support of Thames Valley Police, which fact may assist in understanding the context in which HN33, who use the cover name Lee Bonser, came to be deployed into the women's peace movement. The 1985 report expressly sets out the then Commissioner's critical views about anti-police campaigning in a section entitled Divisive Activity and Police Monitoring Groups. These passages appear to demonstrate that SDS reporting on anti-police campaigning and police monitoring groups was aligned with the view at the very top of the Metropolitan Police Service. The 1988 report refers specifically to the convictions of Andrew Clark and Jeff Shepherd, giving some indication of how importantly they were viewed by the Commissioner at the time. Annual reports for the early 1990s contain multiple references to the events which caused racial tensions to rise and the subsequent confrontations between the far right and anti-fascists. We are also today posting on the website extracts from 4 Special Branch annual reports for the years 1983 to 1987. As with the Commissioner's annual reports, there are no express references to the SDS. However, numerous groups and events on which the SDS reported are referred to. Some passages appear to reflect intelligence that we know was reported by the SDS. However, the assertion that Special Branch have ceased to monitor the plans of animal rights activists in the Metropolis in the 1986 report does not accord with what the SDS was doing. The 1985 report specifically asserts that steps had been taken to address the risk of gathering too much intelligence. It is right to note both that this assertion is not specifically associated with the SDS, but also that we have detected no trace in the evidence of the amount of intelligence that it reported changing. Nor is there any sign that the amount retained by the security service, from where most of the reporting recovered by the inquiry for this period has come from, reduced. The 1986 report expressly refers to Special Branch's contributions to public order threat assessments. It also acknowledges that CND activism was dwindling and assessed that anarchist groups were small and only a moderate threat to public order. Animal rights activism features prominently in the 1987 report, which notes that the Animal Rights National Index, or ARNI, had been formed on the 6th of January 1986 and was under the day-to-day supervision of the MPS. ARNI, we know, became a customer for SDS intelligence. The same report records that there had been 6 improvised incendiary device attacks within the Metropolitan Police District during the course of the year, mounted by animal rights activists. It also refers to the arrest of Shepherd and Clark. More generally, the 1987 report draws attention to what is described as a heavy demand for threat and public order assessments. We have obtained and are posting on the website an exchange of letters in April 1983, which are relevant to the factual context in which HN 65, who use a cover name John Kerry, HN 33, who use a cover name Lee Bonser, and HN 88, cover name Timothy Spence, were deployed. Major General Carl H. Cathay Jr. wrote on the 11th of April 1983 to Mr. Colin Humphreys, the then Deputy Under Secretary Eyre at the Ministry of Defence, about the actions of peace protesters at RAF Upper Hayford. In particular, he raised the risk that if more action was not taken to prevent trespassing into restricted areas, a protester might end up being shot. He wrote, "My concern is not over the security of those resources, for our personnel will see that they are kept secure, and our rules for the use of deadly force are essentially the same as those used by the RAF. I believe, however, that politically, the shooting of a British civilian by an American serviceman would have much stronger political repercussions than would the same action undertaken by a British serviceman." A prompt response was forthcoming on the 15th of April 1983, assuring the General that the situation was causing considerable concern within the MOD and that very serious consideration was being given to the problem by both the MOD and other government departments. We are grateful to the Category H team for drawing our attention in Tranche 1 to the 4th report in the series of 4 under the umbrella title Police and People in London, written by David J. Smith and Jeremy Gray and published by the Policy Studies Institute in 1983. A copy is being put into evidence and posted on the website. The series was part funded by the MPS. The 4th report, Police in Action, carefully documents the deeply ingrained, pervasive sexism and racism which the authors found in the course of their work. I note that the document was relied upon by Mr. Skelton, King's Counsel, as one of the grounds for the admissions which he made on behalf of the Commissioner at the start of the Tranche 2 Phase 1 hearing. A particular challenge which this inquiry has had to grapple with is how to receive evidence from non-state core participants and other civilian witnesses about serious actual and alleged breaches of privacy without further breaching their privacy. It is simultaneously important for reasons of transparency and public confidence in the work of the inquiry that our hearings are as open as we can reasonably make them. Privacy issues are more numerous and more acute in this phase than they have been to date. Although the default position is that evidence will be given in open at hearings to which the public have access, there will necessarily have to be significant derogations from this at times. A small amount of evidence will have to be given in private hearings to which the public are not admitted. On other occasions, evidence will be subject to a reporting restriction order which will prevent onward communication of aspects of evidence which is otherwise given in open. In either case, we will seek to publish, where we can do so without defeating the purpose of the measure, either a redacted transcript or gist of the evidence in question. Inevitably, however, such documents will require careful preparation, which will take time. In addition, some witnesses will be the subject of special measures, either to protect their privacy, the public interest, or to facilitate the giving of their evidence. These will range from remote attendance to screened and voice-modulated hearings. It only remains for me to thank everyone who has been involved in the preparation of this phase of the inquiry's hearings for the considerable volume of work undertaken over the course of several years, often under considerable pressure of time, to enable it to take place. In the case of witnesses, we are conscious that the process of making a witness statement and giving evidence often involves revisiting matters which many find very difficult to relive for wholly understandable reasons.
Thank you. We will resume at 12:15 when Mr. Skelton, King's Counsel, will make his opening submission on behalf of the Commissioner. Mr. Skelton.
So thank you. You and the inquiry's core participants have the MPS's written opening statement for this phase, which will also be published on the inquiry's website. And so this oral opening will briefly highlight some of the points made in that written opening. So in phase one, the inquiry heard the powerful evidence of Francis Bennett, who spoke on behalf of himself and his sister Honor Robson as to the use of their brother Michael Anthony Hartley's identity by HN12, and the evidence of Marva Lewis on behalf of herself and her sister Judy Lewis as to the use of her brother Anthony Lewis's identity by HN78. The MPS is grateful to them and their families for sharing their personal stories with the inquiry and the dignity with which they did so. These witnesses told the inquiry of the shock and the distress caused by the discovery of the use of their family members' identities. The MPS apologises to them and to their families publicly for the profound impact that the use of this tactic has had on them. The use of their loved ones' names by the SDS has compounded the distress they have each suffered. The MPS can assure the families and the public that the SDS stopped using the identities of real persons in the mid-1990s, and this practice is not in use in the MPS today and will never be used by the MPS again. So during phase one, the inquiry also heard from B and Jenny, who were involved in deceitful sexual relationships with HN78, Trevor Morris, B from March 1992, and Jenny in 1995. B and Jenny gave moving accounts of the harm this deceit has caused them. Trevor Morris's treatment of them was unequivocally unacceptable. The MPS was profoundly disappointed that he failed to take the multiple opportunities offered to him by your counsel to take responsibility for his actions and to apologise for the hurt he's caused them. It's also right, sir, to acknowledge that some SDS UCOs were let down by their managers, and although it was or should have been obvious to all UCOs that sexual relationships were unacceptable, the MPS failed to make this clear and failed to provide training and guidance on ensuring their avoidance. Trevor Morris gave evidence that he asked for help on these issues and received none. That too should not have happened. So during this phase, the inquiry will hear powerful evidence in respect of two family justice campaigns, from Richard Adams in respect of the justice campaign for his son, Roland Adams, and John Burke-Monerville in respect of the justice campaign for his son, Trevor Monerville. Both campaigns were reported on by SDS officers who were following their existing targets into them. However, as soon as the UCO's targets' interest in the campaigns had been tested, the reporting of them on them ought to have stopped. The information associated with the campaigns ought not to have been retained, and it is particularly indefensible that this intrusion occurred at a time when the families needed the assistance of the police in the pursuit of justice. The MPS apologises to the families of Roland Adams and Trevor Monerville for the fact that this intrusion occurred. So during the 1980s and into the 1990s, the animal rights movement became increasingly active across the country, and militants engaged in serious crime in the name of animal rights. The so-called Animal Liberation Front and the Animal Rights Militia were at the forefront of this violent activity. The intended victims of these attacks came from all walks of life and from across the political spectrum. Individuals could be targets of criminal behaviour for the job they did, who they were, or what they wore. Businesses, large and small, were attacked because their trade was contrary to the beliefs of the movement. Militants placed bombs under cars, planted incendiary devices in department stores, and conducted terrifying home visits. One of the covert resources MPSB had at its disposal from within the SDS was long-term undercover operatives. The decision to deploy UCOs to identify and gather intelligence on militant members of the animal rights movement was therefore justified in the face of the widespread and serial animal rights-related crime prevalent in the 1980s. However, the MPS recognises the inquiry will also need to explore how close UCOs were to aspects of the matters upon which they reported, what value their intelligence had for those who received it, and whether UCOs encouraged others to participate in crime. It will also need to consider the sexual misconduct of UCOs, which the MPS deplores. But these issues are distinct from the preliminary question as to whether the deployments were justified at the outset. So the lengthy deployment of Robert Lambert from June 1984 to January 1989 demands a particularly thorough examination by the inquiry, as Mr. Barr has outlined today. Although he was the second officer deployed into the animal rights field, it's likely that he was the first in this field to engage in a deceitful sexual relationship. He had at least 4 such relationships. The first began in 1984 with CTS, who's not a core participant in this inquiry. In 1984, he also began a relationship with Jackie, who features in his reporting, and fathered a child with her, TBS. His third relationship began in 1986 with another woman, RLC, who is also not a core participant. And finally, he engaged in a sexual relationship with Belinda Harvey between 1987 and 1988. So the MPS has previously apologised to the women with whom Lambert had sexual relationships whilst he was working undercover. The MPS also wishes to take this opportunity to acknowledge the accounts provided by Lambert's son, TBS, and to apologise to him for the distress he has suffered, including growing up without knowing his true parentage. The MPS should not have allowed Lambert to behave in the way he did. It will do all it can to ensure that TBS receives answers to his questions during this inquiry. Lambert is also accused of writing in whole or in part the so-called McLibel leaflet. He's accused of being a participant in crimes and encouraging others to commit crimes. Some of the alleged criminality is extremely serious. Lambert's accusers are not limited to those that he spied on. HM 109, a former manager, alleges that Lambert headed a group of UCOs determined to protect Stephen Scutt. It is alleged that Lambert physically assaulted and threatened HM 109 in an attempt to stop him taking action against Scutt. Despite this, the contemporaneous management view was that Lambert had a highly successful tour of duty, culminating in him being put forward for and being awarded a commendation by the then Commissioner. His deployment appears to have then left a dangerous legacy within the SDS by setting a gold standard against which other UCOs were judged and judged themselves. The inquiry will also wish to consider the extent to which this contributed to and reinforced the growing culture of exceptionalism and impunity within the SDS in the 1980s, in which unprofessional conduct went unchallenged and undisciplined. So Robert Lambert was not alone in engaging in deceitful sexual relationships. Each of the other UCOs deployed in the animal rights field engaged in sexual activity during their deployments. At the very least, the following relationships took place. HN11, Mike Chitty, had a sexual relationship with Lizzie, who's no longer a core participant, between 1985 and 1987, and continued contact with her after his deployment into 1990. He's also admitted other sexual impropriety. HN87 admitted during the Rule 9 process that he had engaged in some sexual activity with 4 women on different occasions during his deployment. John Dines had a sexual relationship with Helen Steele between 1990 and 1991. Andrew Coles had a sexual relationship with Jessica between 1992 and 1993, and there are other allegations of sexual impropriety. HN1 engaged in a sexual relationship with Denise Fuller between 1993 and at least 1994. These relationships were all unequivocally wrong. The evidence given by B and Jenny in Phase 1 of Tranche 2, along with that of Madeline in Tranche 1, demonstrate the devastating long-term effects these deceitful relationships have had. The NPS is particularly disappointed that some of the former officers who behaved in this way have not fully supported the work of this inquiry by providing a witness statement or by agreeing to provide oral evidence through which their account might be tested. The public rightly expect police officers to be accountable for their actions. Those women who have been directly affected deserve this minimum courtesy. So in respect of the issue of management knowledge of deceitful sexual relationships, the MPS has already made clear in its Phase 1 opening that it doesn't accept the general level of ignorance about relationships professed by the Tranche 2 managers. At a minimum, information arose that merited further investigation, and the known possibility of relationships occurring demanded vigilance, critical inquiry, explicit prohibition, and training on these points, as well as practical support. None of this appears to have occurred. Some of the SDS's former officers and managers may take a different view, but on behalf of the Commissioner, I wish to restate what was said in the opening statement for Phase 1. The prevalence of sexual misconduct on the part of SDS officers in the T2 period, the general disregard for the personal autonomy and dignity of the women affected, together with the inaction or indifference of their managers in response, is a clear and acute manifestation of a widespread and enduring culture of sexism and misogyny in the MPS, for which the MPS unreservedly apologises. So in respect to the issue of UCO criminality, arrests and involvement in criminal proceedings, SDS managers and UCOs appear to have been fully aware of the prohibition against acting as an agent provocateur. However, there is little evidence of any formal pre-authorisation of criminal activity as would occur today in appropriate circumstances. SDS management evidence remains mixed as to whether such conduct would have been authorised, although most managers appear to have considered activity such as fly posting and low-level public order offences to be a necessary part of the UCO maintaining cover and building credibility. So in every case in which a UCO was to appear in court as a defendant, a senior MPS manager should have directed that disclosure be made to the prosecutor so that appropriate decisions about the prosecution could be made. Misleading the court, including by simply failing to attend, was not acceptable. Failure to attend also created a risk of an arrest warrant being issued in the name of the real deceased person whose identity the UCO was using. It's also a matter of concern that there's no evidence of investigators, prosecutors, or courts being informed when SDS officers were not defendants but were closely involved in the events in question. Such disclosure should have been properly considered in each case as part of the fair trial protections of those who are being tried. As has been stated throughout this inquiry, the MPS acknowledges that referrals to the Miscarriage of Justice panel will be necessary, and it will continue to assist the inquiry in its work towards identifying the appropriate cases. So turning now to the penultimate issue I'd like to address you on, the justification and value of the SDS's deployments. It's not yet possible for the inquiry to reach a settled view on the two important issues of justification and value. Proper and fair consideration of these issues requires evidence from the SDS's intelligence commissioners and its customers. So far, the only such evidence is the corporate witness statement of Witness Y, a Deputy Director of the Security Service, the state body with primary institutional responsibility and competence for the assessment of subversion throughout the Tranche 2 period. Witness Y is not, however, being called to give oral evidence, and their written statement has not been challenged by the inquiry. Therefore, in fairness, the inquiry's starting position must be that the investigation and monitoring of those groups identified as subversive by the Security Service was justified and a proper aspect of the responsibilities of Special Branch of which the SDS was part. The MPS's position is that if the issues of justification and value are to be considered and reported on by the inquiry, it must now secure evidence from the balance of the SDS's commissioners and customers. That is, those commissioning the intelligence in Special Branch operational squads, and those then receiving and using the intelligence within those squads, within the MPS public order units, within the national collation indexes such as ARNI, and of course other police forces. Without this evidence, sir, the inquiry's understanding of the purpose and the use of the SDS's work will be incomplete, and there is a real risk that its conclusions will be imbalanced and unfair. So finally, I'd like to make these concluding comments on behalf of the MPS. As I've said, there was a clear justification for the covert infiltration of the militant aspects of the animal rights movement in the 1980s. However, in practice, the SDS's deployments were marred by the misconduct of its officers. The MPS accepts corporate responsibility, first for the systemic management failings within the SDS that are demonstrated by extensive and repeated misconduct in the area of deceitful relationships over many years. Second, for the general misapplication of the duties and responsibilities in respect of UCOs appearing in courts and the responsibilities to criminal defendants who unwittingly interacted with UCOs. Third, for the overall tone and content of reporting which was not subject to management intervention. Fourth, for failing to provide adequate welfare and post-deployment support. And fifthly, for the aversion to disciplining wrongdoing and allowing a culture of impunity thereby to grow. However, sir, it's important to make clear that the SDS's managers dealt with a wide range of different and challenging issues with varying degrees of success. As the inquiry will in due course see, their management styles varied and to some extent were more effective than others. In assessing the management of the SDS, the inquiry should therefore take a properly individualised approach, assessing what each manager did or could know and how they responded to the issues before them. However, sir, as I've said, the final assessment of the justification for and value of the SDS's work overall, as distinct from the questions of conduct and management, must await the evidence as to how the SDS operated within the wider intelligence community, in particular the commissioners and customers of its intelligence. Sir, thank you.
Thank you very much indeed. Can we now hear from Mr. Sanders, King's Counsel, for those officers represented by the designated lawyers?
Sir, Mr. Sanders has still not joined the call. May I suggest we rise for 5 minutes and we can find out where he is, sir? Yes,
Mr. Skelton has been commendably succinct, and Mr. Sanders and those who follow him later on this afternoon ought to be prepared to begin slightly earlier than the scheduled time. Mr. Sanders, a little earlier than anticipated, but thank you for being ready.
Thank
Thank you, sir. Good afternoon. Apologies for I had to leave one link and come into another, hence the delay. Shall I start?
Please do. Forgive me, I was silent to let you do so.
Thank you, sir. The designated lawyer represents the following officers in the next phase of Tranche 2. So there are two former undercover officers. That's HN1 cover name Matt Rayner and HN122 cover name Neil Richardson. One back office detective sergeant, that's HN32 Michael Couch, and three managers at either detective inspector or detective chief inspector level. So HN39 Eric Docker, HN69 Malcolm McLeod, and HN109. So I'm going to address you today briefly on three topics which we've canvassed in our written opening. The first is the conduct of the hearings, and in particular a number of concerns that we have arising out of the conduct of the previous phase of Tranche 2 in July, the topic of sexual activity and sexual relationships, and then very briefly the topic of the Tradecraft Manual. So to begin with, the conduct of the hearings, sir, as we've set out in our written opening, a key concern raised by a number of my clients who have followed the proceedings or given evidence is that the inquiry appears to be conducting a two-tier process whereby police witnesses are subject to heavy adversarial challenge, often on matters of small detail, and civilian witnesses are subject to no challenge at all. This is, of course, an inquisitorial process. No one is on trial in this inquiry, and no one is less deserving of the same courtesy as anyone else. All my clients have voluntarily given up their time to make statements in an effort to assist the inquiry, but the conduct of the proceedings in July, coupled with the interim report and the statement that you've made that the lessons to be drawn from the inquiry are largely self-evident, has left the impression on many of them of predetermination and of an inquiry that's going through the motions. If an individual has done wrong or could have done better, it is of course right that that is explored and tested in evidence. But in our submission, it's not right that individuals who did what was asked of them, did not misconduct themselves, should be belittled and sneered at simply because they served as police officers in a different era. As we set out in our written opening, the phase 1 hearings of Tranche 2 were listed from 10 a.m. to 4 p.m. The majority of police witnesses, including my clients, were in their 70s, retired, giving evidence about events of 30 to 40 years ago, and being questioned about statements that they themselves made between 2 and 4 years ago. All of them gave evidence for more than 7 hours, and most sat beyond 6 o'clock in the evening. In our submission, it's an unacceptable way to conduct hearings, particularly for this cohort of witnesses, and it's bound to produce fatigue, mistakes, and poor quality evidence. And one of the consistent points being made by my clients who had followed proceedings was remarking on how very differently civilian witnesses were treated. In terms of civilian witnesses, it is of course right that the inquiry hears from women who received intersexual relationships with undercover officers and others who recall interacting with undercover officers. But if an individual does not recall interacting with an undercover officer and is simply giving evidence about a group that was reported on, the need for them to give unchallenged oral evidence is not obvious. The inquiry is not investigating what happened at particular public order events or the maintenance of public order at such events, and it's not investigating instances of disorder or the risks posed by particular groups. For example, it's not hearing from uniformed officers responsible for policing events such as Greenham Common, Wapping or Welling. It's not examining related threat assessments or operational orders, plans, briefs and debriefs. In those circumstances, sir, we submit that the perspectives of a selection of those involved with groups who wish to engage in the inquiry may be valuable, but it does not need to be heard orally simply for the sake of it, particularly in our submission when questions about public order and disorder are being asked and answered on the false premise that disorder means violence. And this brings us back to a point we've made previously. Public order policing was and still is about ensuring an orderly, tranquil state of affairs where all members of society can go about their business and leisure and use the public highways without let or hindrance. Demonstrations and protests in public spaces can disrupt this and therefore can require a police presence. It is a question of risk and the assessment of risk and the allocation of appropriate resources. Most groups that were reported on by the SDS, they were all lawful groups. Most had, of course, moderate, thoughtful members with no interest in disorder or violence. But this does not mean that protests and demonstrations that they were involved in did not risk disorder or require public order policing. In particular, other members of the groups and other people attending might have felt differently or had a different disposition towards violence and disorder. There was also risk that could arise in connection with a combination of different groups converging on the same protest or demonstration, and the further risk factor of counter demonstrations or confrontations between demonstrators and protests, even if those on one side were entirely peaceful. The SDS was tasked with gathering intelligence that would help with that process. It was not confined solely to the avoidance of riots. So I don't think I need to address you on anything I've said on the topic of the conduct of the hearings. We've given some specific examples in our written opening statement. The second topic I want to address you on briefly is that of sexual relationships and sexual activity by undercover officers. As we've said in our written opening, sir, all sexual misconduct by undercover officers was wrong and should be condemned and not condoned. However, not all of that activity was equivalent, and not all of it represented relationships in the ordinary sense of the term that most people would understand. For example, the admissions of HN12, who was a client of mine before he died, was of one instance of kissing and one of oral sex. HN67 admitted a one-night stand, and HN87 has admitted 2 instances of what he described as sexual fumbling and kissing without tongues. Those episodes, sir, while they involved misconduct and were unacceptable, cannot be described and should not be described as sexual relationships. That's not how most would consider them. During Tranche 2, 5 or possibly 6, depending on the inquiry's findings in relation to HN2 Andrew Coles, 5 or 6 of 37 SDS undercover officers had sexual relationships with members of the public in the sense that the term relationship is ordinarily understood. While this is a significant and unacceptable minority, it means that more than 30 members of the SDS did not. And this is relevant when you come, sir, to consider what managers could or should have known, because of course they were not faced solely with those small number of officers who were misconducting themselves. They were faced with a much larger cohort, most of whom were not. There's no evidence from any undercover officer or former undercover officer that the designated lawyer managers or back office staff being dealt with in Tranche 2 were informed or aware of sexual misconduct by undercover officers, let alone sexual relationships. In our submission, the risk of totaling every instance of an undercover officer who engaged in sexual activity and then counting that as sexual relationships, is it gives the impression that all of those were on a par with Bob Lambert. And then it leads to the conclusion of condemning everyone as having been part of the culture of sexism and misogyny. That is not a description that my clients recognize of their time in the police in the 1980s. Taking that approach also cannot explain and tends to obscure the fact that the risk of sexual attraction and encounters goes wider than just straight male undercover officers. You are due to hear evidence in tranches 3 and 4 about sexual misconduct by female undercover officers. And there was also the claim in the True Spies documentary about a gay undercover officer referred to as Steve. Attributing all such activity to sexism and misogyny is an oversimplification. These may have been factors in some cases, but each needs to be considered on its own facts without oversimplification and bearing in mind the complicated psychological factors and impacts connected with undercover operations. So finally, the Tradecraft Manual. And what I'm referring to here is the 44-page Tradecraft Manual with the reference number MPS 0527597. I think there are in fact 2 versions, but that's the document I'm talking about. Much has been made of this document. It was, and still is, an unfinished draft. Some parts of it are written in the first person as a personal account, and some are not. There are different versions. It has never had the official status, endorsement, or use that many have assumed. And in our submission, Tranche 2 is the first opportunity that the inquiry will have to explore this and hopefully clarify it. You'll be hearing evidence from HN2 and also HN10 Bob Lambert, albeit that his evidence about the Tradecraft Manual might be in Tranche 3, I'm not sure. But in our submission, it is important that some of the myths about this document are dispelled. It didn't have the official status, endorsement, or use that many have assumed. So I think that's all I need to address you on, and thank you for your time.
Thank you very much. Because Mr. Skelton and Mr. Sanders have been commendably succinct in their submissions, the time allowed for them has not been fully used up. It was intended that there would be a break at 1:15 and a resumption at 2:15. I am now going to rise and propose that we resume at 10 to 2 rather than at 2:15. Could I therefore ask Mr. Sheldon, King's Counsel, who's going to make submissions on behalf of the Home Office, Mr. Whitaker, Mr. Rajiv Menon, King's Counsel, Ms. Charlotte Kilroy, King's Counsel, and Mr. James Scobie, King's Counsel, if they would be prepared, please, to make their opening statements roughly half an hour earlier than they had anticipated. Thank you.